Hello, good morning, one and all. Today we are going to discuss the basic terms which are quite important in understanding the Evidence Act. So, firstly, the Evidence Act would be applicable to all the courts other than the court martials, which is under the Army Act, the Naval Disciplinary Order, or the Air Force Act. And now we're going to look at the interpretation clause of the Evidence Act. So the first definition includes what is courts. The courts includes all the judges, magistrates, and all the persons except the arbitrators which are authorized to take the legal evidence. Now, what's a fact? Facts are divided into two categories, which are one is the physical form, which is perceivable by five senses, and the second is the psychological conditions of what a person might be thinking or feeling, that is unconscious. So we'll see the illustration second, which says that a man heard or saw something is a fact. A certain opinion or certain repetition that a person has is also a fact. Relevant. Relevant simply means that something which is in connection to one another or in reference to the provisions that are mentioned or that are in question. Facts and issue means and includes. It means that this is an inclusive definition. It means that or is concerned about the connection with other facts or the existence or non-existence, the nature or extent of any rights, liabilities, or disability asserted or denied in the suit, necessarily which is related to the CRPC or Code of Criminal Procedure. In simple words, we can say that facts and issue are generally related to the criminal matters, whereas issue of facts which are given in the explanation are related to the civil procedure, which says whenever under the provision of the act for the time being in force relating to civil procedure, any court records issue of facts to be asserted or denied in the answers to such issue is known as fact in issue. So one definition or one difference would declare that facts in issue are related to the criminal matters, whereas issue of facts are related to the civil matters. And in facts in issue, there is the need for the irrebuttable presumption or the absolute truthfulness of the statement should be proved, whereas in the civil procedure, which is the issue of facts, only the preponderance of the facts is relevant to determine whether the thing or the circumstances have took place or not. Now we would get to what is documents. So a document means any matter expressed or described upon any substance by means of letters, figures, or marks, or by any other means which are intended or are used for the recording the matter. It can be lithographed, printed, or an inscription. Even the painting or the caricature on a wall can be recorded as document. What is evidence? Evidence would mean all the statements which the court permits or requires to be made before the witness under a given circumstance in relation to one of the facts or what the case in the issue is. So all the things which would lead to the presumption or to conclude the fact that the circumstances took place or to prove in the court of law that the required circumstances took place at the time of the commission of an offense are known as evidence. All documents, including electronic records produced for the inspection of the court, are also included in this. All these are known as documentary evidence. Then next we have proved. disproved, and not proved. So, firstly, we would see what is proved. Proved in simpler terms would mean that the ordinary man looking at the circumstances would perceive the facts to be true, or that they are so probable that in the ordinary supposition we see that there would be the existence of these certain facts. For example, if in the case of R versus Richardson, we see that a person gets out of the office, finds a place where he meets another woman, and there we see that he ravished her, and then after that took her to a certain area and murdered at that place. Here we see that the occasion of getting out of the office and then leaving that place where he ravished her, and then afterwards killing her after the rape incident would be all considered as the occasion, cause, and the circumstances which are surrounding and giving the person opportunity to commit an offense. Disproved. A fact is said to be disproved when, after considering the matter, the court is so probable that there will be no existence, or those facts which are stated are not really in existence. Now, what is this? Not proved. The facts are said to be not proved if they are neither proved or disproved. That is, the court holds a certain level of inconclusiveness regarding the existence of the facts in the matter, and thus the court is having an antagonist view whether the certain facts are actually present or not. Next to this, we see that in the landmark judgment of Trilokinath versus State of UP, it is said that the Indian courts would not work on the principle that falls in one thing but falls in everything. The court would hold the discretion, and he would try to disintegrate and with clear decision try to establish the facts as we take out the grains from the chaff. So the evidence should be complied with and dealt with clear precision and with a distinction so as to not disregard the whole facts as a whole. We had to look at the circumstances and try to derive the meaning from it. So that's all about what the basic idea of the Evidence Act is. Apart from this, I would like to include two case laws which are related to the Evidence Act and which are as follows. So the cases are about the tape recording and the admissibility of the records which are with the moneylender. So Shobha Rani versus Ravi Kumar, the tape recording statements would be admissible as the evidence. K.S. Mohan versus Sandhya Mohan, the certified copies with the moneylender as to advise or to make it appear that the certain situations or certain amount of money was taken and the books of accounts are taken into account. All these would include as the admissible evidence. Thank you so much.